Welcome,
All
everyone.
right.
As you might have seen in the agenda, we'll start with Yannis. He's a policy advisor on the European Parliament, and we will bring us a little bit of insights on the travel regulations for the EU. Yannis, yeah, the floor is yours. I have mentioned before that everyone can drop the questions in the chat, and we will try to get to them at the end of each speaker's presentation. If there is no time for everyone, for everyone's questions, then we will get back to you either in form of content or, yes, on social media, okay? So yeah, Yannis, you're up.
Thank you, Hannah. Thank you. And thank you for having me here. It's really an honor to be in a meeting like this. In the process of reforming the travel rule and including extending it to crypto transfers. I mean, we've had meetings with many different groups, of course, many different stakeholders, including the industry, but it's always good to be in such meetings again. And I hope I can make myself clear, but if not, then please interrupt me and or ask questions at the end. So I'm sure you all know that 8 days ago, the European Parliament, the Commission and the Council agreed or had a political agreement on extending the travel rule to crypto transfers. And the following day, and this is also important, so 7 days ago, a political agreement was reached on MiCA, the Markets in Crypto Assets regulation. And that actually is a broader piece of legislation that will constitute the framework for the operation of crypto asset service providers, as we call them, or virtual asset service providers in FATF language in the EU. So maybe next slide. Yeah, so the main act here is the transfer of funds regulation. This is an existing piece of legislation that that described the travel rule for traditional wire transfers. This has now been recast to extend it to crypto transfers. And as I said, there is a sister regulation, MiCA, the Markets in Crypto Assets regulation, which provides the broader framework. It also importantly provides some of the definitions that we need for TFR, the transfer of funds, which is why the entry into force is linked. We'll get to that towards the end of my presentation. And then perhaps good to know that going forward, also the AMLD, the Anti-Money Laundering Directive provisions that will fully apply to crypto asset service providers. The first two, TFR and MiCA, are regulations, which means they directly apply. AMLD is a directive, so every member state transposes this directive in order to achieve the legislative goals, the legal purposes of it. But you may see some differences from one member state to the next. But TFR and MiCA have direct application in AMLD. If you want to know exactly in specific countries how it is implemented, you need to look into the national legislation. But all three are relevant for the travel rule in crypto. Okay, next slide. Then what is the scope? This is somewhat analogous, but there are differences to the scope. So is there somebody trying to say something? No, okay. So the scope is analogous, but not entirely the same as for wire transfers. First of all, you will all know that the EU has decided to not apply a threshold. So the travel rule will apply for even the smallest transfers in crypto assets. There are different reasons for this. They're also explained in the legislation. One of them is that it's much easier, we believe, to smurf in crypto transfers or to quickly open and close wallet accounts. Another one is volatility in market prices, and there are a couple of other ones, but they're explained also in the legislation. Another important distinction between wire transfers and crypto transfers is that we consider all crypto transfers international. We don't have domestic transfers, because for wire transfers, the 1,000 euro threshold applies to international transfers, but for domestic, different thresholds sometimes apply. But for crypto, we consider that everything is international because this is such a global environment. Then who are under this scope? So transactions from CASP to CASP, so hosted wallet to hosted wallet, and between hosted and unhosted. We also have a provision for intermediary CASP, just like I believe the UK published 1 or 2 weeks ago they would do. And this was also a recommendation from the FATF, the Financial Action Task Force. But importantly, P2P is excluded. May seem logical to some of you, perhaps others have had questions about this, but it's not covered. So the travel rule will not apply for unhosted wallet to unhosted wallet transfers. Now, then what more do we ask? So we ask for a transfer between two CASPs, so between two hosted wallets, for these CASPs to verify the information that was given to them by their client, right? So that we know this information is accurate. Again, the same thing banks need to do. But there is one very important distinction here, even though it has only very narrow application, I think. When there is a transfer between an unhosted and a hosted wallet, and this transfer is more than 1,000 euros worth of value, and if the unhosted wallet is owned by the client of the CASP, or this client claims the unhosted wallet is owned by him or her, then we ask for proof of ownership. Okay, we are technologically neutral. We don't say what that looks like. The European Banking Authority will come with guidelines going forward to give a bit more of a steer to the industry, but we haven't dipped our toe into the different protocols that are possible, or screenshots, or live micro transfers with video showing that you control it, or cryptographic signature. So we don't go into that, but we just say we need a proof of ownership then. But in all cases involving unhosted wallets, we want enhanced due diligence, and that's always risk-based and to quite an extent at the discretion of the CASP. Next slide. And I'll try and go a bit faster because I think we're burning through my 10 minutes. So the content of the travel rule information, you will find this in the legislation. So I will not go through the details, but this is essentially analogous to what banks also need to provide for wire transfers. Next slide. Yeah, we spent quite some time on privacy. Of course, because this is one of the concerns from the industry, also from consumers. It is important to understand that the GDPR, the EU's General Data Protection Regulation, applies fully. Okay, and the GDPR is quite strong because it is based on a fundamental right to privacy that you have in the EU. It also means that even if the travel rule or the TFR stipulates that personally identifiable information must be sent with a crypto or in parallel to a crypto transfer, but if this data is not safe on the other side of the transfer, it cannot be sent, right? If the CASP believes that the data is not safe on the other side, it cannot be sent. So there will be different sets of guidelines from the European Banking Authority and from the European Data Protection Board, giving more of a steer to the industry how they need to interpret all of this. I can just say now that the GDPR applies directly to the EU and the European Economic Area, right? So Switzerland, Norway, Liechtenstein. So those countries, 30, are always under the GDPR, and transfers can always be considered to be safe, because it's not the CASP's responsibility to make sure that the supervisors, the national supervisors in these other countries apply the GDPR. That's their role. Also, there are 13 or 14 countries in the world that the European Commission has given an adequacy decision. They said the privacy protections there are essentially equivalent to what we have in the EU. So then it's also safe. For the rest of the world, CASPs will have to look at Chapter 5 of the GDPR, which tells them the options they have to ensure data privacy for the transfer of personally identifiable information. Now, and if the data is not safe on the other side, the PII cannot be sent. Maybe the crypto can still be sent if the AML risk is very low. The FATF also says this, and we have instructed the European Banking Authority to give guidelines to CASPs, how they can identify these situations, how they can interpret these situations and make an informed decision whether or not to send the crypto, even if the personal data is not safe. Okay, so the next slide. Yeah, just very briefly, I already mentioned, going forward, crypto asset service providers will come under the AMLD, and so they're going to have to implement all the EU's anti-money laundering measures, which means sanctions, screening, customer due diligence, counterparty due diligence, the whole lot. They will have to apply all of that. And in the process of this TFR recast, we've also amended the EU's AMLD to ensure that all of this is reflected in the legislation. Next slide. Yes, then the timeline. What we've had last week were political agreements on TFR and on MiCA, not the final adoption. There's still quite a bit of technical work that needs to be done, and then the approval by vote first in the competent committees of the European Parliament, and then the plenary of the European Parliament, then the signing and the publication in the journal, and so all of that's going to take a little bit of time. So I think that the publication in the EU journal will probably be at the end of the year, maybe December, and then the clock will start ticking on the entry into application, which will be 18 months after the publication in the journal. So I think that in the summer of 2024, my best educated guess, summer 2024, all of this will start to apply. So there still is quite a bit of time for the crypto industry to get their head around, okay, what's coming at us. And the next slide. Yes, so then just very briefly, probably most of you will know, there are two layers essentially of supervisory authorities, that are going to descend on the crypto industry. First of all, the competent authorities of the member states. Some EU member states already have quite a lot of crypto regulation in place, others don't. But these would be your first point of contact. So BaFin in Germany, AMF in France, AFM in the Netherlands, etc. At EU level, it will be first of all EBA, European Banking Authority, but the EU is also working at the moment on a further overhaul of its anti-money laundering legislation, and it's creating a new anti-money laundering authority, and that will take over the supervisory tasks of the travel rule from the EBA. Other other parts of the crypto world will still be supervised by the EBA or by the ESMA, but for the travel rule, this will be first of all under the EBA, and it will move to AMLA later on, probably in 3 or 4 years' time. Okay, that's it. I hope it was somewhat understandable, not too fast. I think, as Hannah said, the slides will be shared, but I'm happy to have any questions or comments.
So I will go through some of the questions here. We have quite a lot. Okay, so Alison asks, is a transfer from CASP to unhosted wallet not owned by CASP clients legally possible?
So a transfer from a hosted wallet to an unhosted wallet not owned by that client.
Yes.
I think in crypto world, anything is possible. There are a few jurisdictions in the world, of course, that have banned this, but the EU isn't banning it. So the EU legislation will not ban hosted to unhosted owned by third parties, which I think is either the intention or the consequence of the Swiss legislation, but will not be the EU legislation. So this will still be possible. And in that case, if the unhosted wallet is owned by a third party, then the CASP where the wallet is hosted, the originator of the transaction will have to apply enhanced due diligence to decide, they'll have to evaluate the risk. Can this transaction safely be made or not? Are the AML risks or other risks too high? So it will not be banned in the EU.
And we have a question from Elliot. I think you briefly mentioned, but regarding the timeline, when are crypto companies going to be required to implement these solutions so they have to be compliant?
Yeah, exactly. So as I said, I think the final publication, the final adoption and publication of this legislation will be at the end of this year. And then the clock starts running. We have an 18-month implementation or entry into application delay. In that time frame, these 18 months, you will also see these guidelines coming out from the European Banking Authority, from the European Data Protection Supervisor. So these various guidelines for industry on how to implement all of this. And then indeed, I expect it in the summer of 2024, this will all kick in. But of course, this is important perhaps to say that quite a few member states already ask certain things of crypto. There are even member states that have already implemented the travel rule in one form or another. And this will not be abolished at the moment. This will apply until TFR takes over. Yeah, so if you are dealing with member states, for instance, Germany, where some of this already applies, they've already implemented some of the FATF recommendations, and this will, of course, continue to apply.
And thank you, Jens. Last question. Asman asks do you have to conduct due diligence as required by FATF on the counterparty CASP before submitting the TR info, the travel info? I think you also.
Okay, so there are two things here. One thing is an occasional transfer. So there's a difference between customer due diligence and counterparty due diligence. And there's not even 100% overlap with a risk assessment of an individual transfer. If there's a one-off transfer, then CASPs of the originator will not have to do the full set of counterparty due diligence for dealing with the CASP on the other side. However, if they enter into a more structured relation with the CASP on the other side, then they will have to do counterparty due diligence, as will be described in the AMLD. But that's for more structured relations between one CASP and another CASP. If one CASP transfers to another CASP on behalf of their client as a one-off occasional transaction, then they will need to do, they follow the rules that apply for that specific transfer, but not do a full set of counterparty due diligence.
Perfect. Thank you so much, Hannes, for sharing with us. I think those were very valuable insights. And yes, as I said in the beginning, I don't know if everyone was here, we will get to your questions afterwards in form of content or getting back to you if you subscribe to our updates, that we will share the links on the chat and also at the end of the presentation. Also, those slides will be shared. I will share the links on the. Now,
yeah,
Willem,
thank you so much, Hannah. And I will mute, but I'm still staying in the meeting. So if anything, I'm still here. Thank you.
Thank you very much, Hannes, for your very knowledgeable inputs. Yeah, Willem, you're up.
Thank you, Hannah. Welcome all. Thank you for having me. My name is Willem-Jan Smits. I'm a lawyer and co-founder at Watson Law, and our firm specializes in all the legal aspects of crypto, especially financial law and now the AML laws that are coming up and are already enforced. We have quite a broad client portfolio, but for this it's important that we focus on clients that have already registered under the AML directive with the national national competent authorities. We did some registrations, or quite some registrations in the Netherlands, but also have experience with registrations in other countries. And yeah, I'll go into that in a bit. There will maybe be some overlap with Janus, but yeah, since all this regulation is so new, I don't think that is a problem. Okay. The crypto regulation in the EU, where is it coming from? We have to distinguish between behavioral supervision at the one hand and the AML regulation that that Janus has talked about. So in the traditional financial markets, we basically see three main instruments of legislation. That is regarding the issuance and listing of assets. So that's regulated under the prospectus regulation for traditional markets. Then we have the services, for instance, trading venues, placement, so primary, secondary markets, those kind of things. That's under MiFID II. And we have the market abuse regulation, which goes into insider trading and those kind of things. Also very important for crypto, obviously. What we are going to see is that there will be a markets and crypto assets regulation covering all those three main topics, but in one legislative instrument. So there will be the markets and crypto assets regulation, either issuances and listings of crypto assets service providers will be under here, and also a bit of market abuse regulation. So that's in one package, but it is, you could say, derived from the regulation of the traditional markets. So this markets and crypto asset regulation, as the name says, is a regulation and will be directly applicable throughout the EU. And that is very important. As we will see that there are quite some licensable activities under MiCA. And what we've seen today is that certain crypto asset service providers had to register with the national competent authorities. But there was a national registration, and a service provider that wanted to be active in all throughout the EU had to register with 27 member states, and that's not really convenient. So this regulation is provides a better framework, so to say. It's going to regulate the entire industry in the entire EU. There are basically two types of licenses: licenses for the issuance of stablecoins. So that's electronic money tokens and asset reference tokens, and a license for crypto asset service providers. And that will be 12 different services. I'm not going to name them all here, but an important one is custody, all kind of trading services, trading, exchange, order routing, placing. So again, primary and secondary market, transfer, and advice portfolio management. And also under MiCA will be regulations regarding the issuance of, let's say, normal crypto or other crypto assets, so not stable coins. They will have to issue a white paper and register it with the national competent authority. And like I said, there will be rules on market abuse. It's an ambitious package that will govern the entire market. However, if you compare it with the traditional instruments I talked about in the beginning of my presentation, it is still a fraction of that regulation. So MiCA 2 is already to be expected. There are quite some people, regulators, also pointing that out, that MiCA is a good step forward, but is not as elaborate yet. So that was the behavioral supervision regulation that's to be expected, and we have already some AML CFT laws in the EU. The first real crypto law, so to say, was AML D5. It introduced a registration obligation for two specific services, namely the custodial wallet and the crypto to fiat exchange. Like I said, we have been involved with several registrations throughout several jurisdictions, and in practice we have seen that these are really, really different. For instance, the Netherlands and France are very strict, both gold-plated. The European regulation, but there are other member states that are very easy, and it is just really a registration. In the EU, in the Netherlands and France, it's comparable to a license, and for instance, in Poland, it's just a registration. Okay, well, then this EML directive, this fifth EML directive, will be followed up with an AML package, and this AML package consists of 4 different instruments. The AML authority, that was already mentioned by Jannes. There will be an AML regulation, and this regulation will be basically the material rules out of AMLD5 will be transferred to a regulation. And this is good because then this national registration regime I talked about will be out, and basically replaced by the license system of MiCA. Then we will have the 6th AML directive. This will be a directive with formal laws about national competent authorities, fee use, exchanging information between the supervisors, etc. And then there will be the transfer of funds regulation as part of this entire AML package. It was the objective to have MiCA and the AML package enter into force at the same time, but unfortunately this will not be the case, most probably. So the transfer of funds regulation is taken out of the AML package. There was a political agreement on that together with MiCA last week. They will be entered into force at the same time, whereas the other still needs the political debate. Then this travel rule will be implemented in the transfer of funds regulation, and that will be there is a political deal on that piece of legislation. So we have the travel rule, which finds its grounds in the VASP recommendations. 15 is about new technologies, crypto, and 16 is about wire transfer and travel rule for crypto as well. So we have to distinguish for the travel rule between 3 different types of transfer. That is transfers of CASPs between CASPs, a transfer where a CASP and an unhosted wallet is involved, and peer-to-peer transactions. And CASP to CASP transfer, what the CASP need to do is collect, verify, send, and store information on the originator and the beneficiary of the transaction. They also have to perform sanction screening on the originator and the beneficiary. This is already in place for the 2 service providers under AMLD5, but it's not yet in place for other crypto asset service providers, since they are not governed by the European legislation yet. So the sanction screening will be part of this as well. And CASP need to detect and report any missing information. So a receiving CASP need to check whether the sending CASP has sent all information, and if that is not the case, then it's to be detected and reported. Then we have the transfer involving unhosted wallets, and a CASP there needs to collect and store information on the originator and the beneficiary. It has to verify this information also about the ownership of the unhosted wallet if the client is the owner of that wallet for transfers over €1,000. And on all transactions with unhosted wallets have to apply risk-based AML measures. In the Netherlands, we have some experience with these so-called unhosted wallets, since, like I said, DNB gold-plated the AML directive implementation in the Netherlands, and we had already this wallet verification requirement. In first instance, the DNB, that's the Dutch regulator, required from service providers that all wallets were under this verification. But later on, there was a court case and an objection by one of the parties involved, and they changed their position on this one, and there was a risk-based approach taken from there. In the Netherlands, the solutions for this verification of wallets wasn't so pretty, so to say. At the time that it was implemented, there was no real technology available, and what most parties did was use either screenshots of wallets or filming of screen sharing, and that is either not really effective and also really privacy intrusive, so not a real pretty solution. Therefore, I'm happy that we are having this seminar, and that 21 Analytics is developing tools for things to run smoother and better, both from an AML perspective as well as from a privacy perspective. Yeah, like Jan has already also said, but what is really important is that peer-to-peer transactions are not regulated. It's not really well thinkable how this should be brought under regulation, and it would really hinder the EU and innovation here on crypto. So I am personally very happy that the peer-to-peer transactions are out of this regulation. That was it from my side. I'm happy to answer any questions.
Thank you, Willem. That was very insightful. Thanks for sharing. Yes, we have some questions. But the chat is quite on fire here, so I'll work through them. Okay. Regarding, so Mauro has a question. Will AMLA replace or be an addition to current local supervisors for crypto AML, such as DNB in the Netherlands?
It will definitely, or most definitely, not be a replacement for national competent authorities. It will be on top of that. The exact powers and authorities are to be discussed. I'm not aware of what it will be, and I believe it will be a couple of years away for that we see it. It is my understanding that this is the point where most political debate is about. So I cannot really substantiate the answer.
Daria asks, can you please clarify how will the new MiCA regulation interact with FCA crypto registration? Will we require both or one? Yes.
FCA being is a UK question. Yeah.
Yes.
Yeah.
Or maybe you can speak from a Dutch point of view.
No, but you know, like I said, MiCA is a European regulation applying in all 27 member states. So a MiCA license is possible throughout the EU. One license works everywhere. I don't know what the British will do with it. Theoretical possibility is that they recognize such a license. But I'm not aware of what the British will do. The other way around, most probably not.
But I think a related one is, how will the MiCA relate to the AML requirements? That's the question from Arthur.
Yeah, that's a really good question. It's my understanding that let's put it this way: MiCA will bring behavioral supervision to crypto. It's not there yet, so it will be a licensing which will have really look into the behavior of VASPs. That will be there once MiCA is into force. AML is not part of MiCA, but it will be there as well. We already have this registration obligation. This will only go away once the AML regulation is in place, or other patchwork is done. And since that is not there, the registration obligation will be there alongside the MiCA license, and that is a real issue, because we have seen for 12 services you can have a license which is passportable throughout the EU, and there are 2 services under AMLD5 which require local registration. So that is something that we really urgently need to have addressed, to prevent the situation that you need both a license which is passportable and 27 registrations to be able to work throughout the EU. That's a major issue.
Thanks, Willem. Thanks for your presentation and all answers to the questions. As I said in the beginning, I don't know if everyone that is here could get it. We will try to get to everyone's questions afterwards in the form of content, or working with Willem and the speakers after this session. But we will not have time to go through everyone's questions during the meeting. Thank you, Willem.
Thank you, Anna. Thanks for having me.
It was a pleasure. We'll go to Sadri now. He will be talking about unhosted wallets. Sadri?
Hi, Hannah. Hi, everybody. I hope you have a great morning. All right.
Good morning.
So I'm going to share my screen. I'm not sure whether you got my presentation. So let's go here.
Yes.
All right.
Just before you start, I will get to Leticia question. Yes, we will be sharing the questions and answers on our social media in the other formats of content, and you can also subscribe to our updates. So we'll be answering in our communications through email. I will share the link now on the chat so you can register. Yeah, Sadri, you're up.
Yeah, so my name is Sadri Sali. I'm currently a compliance officer with Euronext. They are my client, but I'm not here to represent their opinion. Disclaimer. So I'm not associated with Euronext with regards to the presentation about unhosted crypto wallets. And I'm also a European blockchain and crypto regulatory advisor. So I have clients in different countries, so far only on 2 continents, but keep counting, let's say. So I have a lot of diverse reactions to the proposals coming from the European Union. So for instance, I actually have a client who is an unhosted crypto wallet, hence the reason I'm going to present this topic in detail. And besides that, my research is only focused on AML in the context of the FATF recommendations with regards to VASPs and crypto assets on the European scale. So let's start. My question was in the very beginning of this year, when I found out about the provisional agreement back then, whether it's going to be way more difficult to use cryptocurrency between peers than cash, because it would be a bit outrageous if you would ask me to go to the supermarket and when I'm paying for like 10-20 euros for some bread and something else, but I'm going to buy because of the Doppler effect, you know, you never get only one thing at the supermarket. They are going to just ask me for my ID. And yeah, that's what they intended to do back then with crypto. They wanted us when we sent, actually in the future, when we are going to send a lot of crypto assets, they want us, well, not a lot, like a few hundreds, they wanted us to present a lot of information about us. And in my opinion, especially because not all CASPs in the moment comply with the GDPR, and actually they are from different countries without even an adequacy decision, that's a bit, again, outrageous, in my opinion. Okay, so they gladly changed their mind, and the latest update of on the 29th of June, so last week, says that basically the Council and European Parliament reached a provisional agreement on the rules on information accompanying the transfer of funds by extending the scope of those rules to transfers of crypto assets. What that means, basically, in a nutshell, it will, I'm going to have a lot of overlapping with the previous panelists, of course. So in a nutshell, all you need to go with after this webinar is that CASP transfers between two hosted wallets on CASPs will be subject to the TFR, which is the direct implementation in the EU of the FATF recommendations 15 and 16. And also the same rules will apply when we talk about a transfer of funds or certain crypto assets between a CASP and an unhosted wallet. So your wallet and something that you have on, for instance, Binance, Kraken, etc. But gladly, we have two exemptions, kind of. It's one, but let's say I subtracted two of them, two of it. Okay, so we have an exemption when we talk about a transfer that occurs between two unhosted wallets. So, for instance, I have a MetaMask wallet, and I want to transfer to Hannah some money, but in the shape of crypto assets. All good, no need for requirement, unless that should be to a private wallet, but actually needs to comply with certain AML requirements, and that's the discussion about the third-party beneficiary ownership. I think that EBA will clarify that, honestly, because for me it's a bit vague how they expressed it. So maybe we are going to comply with this for everything over 1,000 euros. But let's see, maybe they will make another exception. So what the EU tried to reach with this? So the main objectives are basically fivefold, in my opinion. So we have financial transparency regarding CASPs and transfers conducted via these parties. And actually, the most important objective is to create a robust framework compliant with the FATF recommendations 15 and 16. And here is very important to notice that according to the latest report of the FATF, only 23% of the countries that are subject to the FATF recommendations have actually implemented those recommendations. So only, I don't remember the number, 12 or 15 or something like that. So 23% out of 50 something countries. Yes, I understand why, because the travel rule was usually set aside by the banking industry because they said we can't do that, and for obvious reasons it would delay a lot of transfers and it would require a lot of human resources. I think that, for instance, in the Netherlands there are more KYC officers now than police officers. Correct me if I'm mistaken, but I think that's going to be changed in the near future. I hope so, at least 2030, something like that, to realize that not everybody will perform money laundering through their accounts of any sort. Yeah, and then they want to ensure a traceability of crypto asset transfers and align with the timeline with the MiCA entry into force. So they want to pass both MiCA and the transfer of funds regulation at the same time. Actually, there are 4. I just got an extra bullet here. Okay, so what's new regarding this FATF travel rule implementation that they want to go forward with is that there is now a necessary requirement regarding information sharing duties from the sender, from the CASP of the sender to the one of the beneficiary. And CASPs are, this is a philosophical question actually, whether they are obliged or responsible or it's their duty, etc. But either way, bottom line is that they need to gather this information and keep it on record for at least 5 years for authorities when they want to prosecute somebody. So they need evidence. The other thing that CASP need to do when we talk about not unhosted, so this is about hosted wallets at the moment. They need to collect and make accessible certain information about the originator and the beneficiary of the transfers of crypto assets they operate with. And which is actually something very peculiar to me, but not quite, because of the GDPR and the French case regarding the extraterritoriality of a regulation adopted and implemented in the EU back then in 2018, I think it came out, or 2019. Now, according to this framework, at least one CASP needs to be registered within one member state, so within the EU. And there's no exception for that. So you cannot conduct transactions on your within the EU if you have wallets from CASPs outside the EU. And there's no talk about an adequacy decision at the moment. Then the last thing to talk about the novelties about this regime is that the legislation exempts some crypto asset transfers, including peer-to-peer transfers and transfers by the CASP acting on its own behalf. Yeah, so basically a member state can exclude if it wants. But only within its borders, the transfers that do not exceed the crypto assets worth of more than 1,000 euros. I'm going to skip this because I'm running out of time. This is something that was already touched upon by my previous colleagues here. What you should remember is that if the transfer exceeds 1,000 euros, then the beneficiary service provider, so the beneficiary's CASP, must verify the information on the basis of documents, data, or information obtained from a reliable and independent source. That's something that will create, I think, a new side market and industry, because we need technology to do this. And there's no time to do that by humans. So, and besides this thing, there's also important to notice that if the transfer does not exceed 1,000, the accuracy of the information shall only be verified if the beneficiary effects regard a payout in cash or anonymous electronic money. That's defined in MiCA. or where reasonable grounds for money laundering exist. And the reasonable ground is something that triggers me, so that requires further research. Because we know what's a reasonable suspicion or reasonable ground, but we don't actually know how it goes in crypto. And now to touch upon the topic that I actually advertised in the beginning on unhosted wallets, I'm going to pose a rhetorical question now that I'm actually going to answer to some extent. Are CASPs required to obtain and verify encompassing information about the originator and beneficiary? Well, it depends, of course. CASPs of the beneficiary have to implement indeed effective risk-based procedures to determine whether to execute or reject a transfer, and ask for the required information before or after making the transfer available on a risk-sensitive basis. So what it happens if the CASP has a suspicion that this repeated party, this party, one of their users, repeatedly conducts transfers with other custodian wallets or with an unhosted wallet, it can refuse, but only if the user will utilize the custodian wallet on, for instance, Binance to send to MetaMask. So if something is shady there, the first party can ask for further information. So what you're going to do with these transfers, that you're going to, yeah, exactly what you're going to do. Otherwise, they can issue a warning and even report them. And this is a bit interesting because it's a bit dispersed, this reporting requirement between the national competent authority here, AFM. Then you also need to do in the traditional market, so probably they will also overtake that role, that competence. Then you need to maybe do EBA at some sort of degree, and there's also the FIU who needs to know about all of this. So what's really important when we talk about a proper implementation of regulations in the crypto industry is that national competent authorities do need to exchange information. So there is another piece of legislation on child sexual abuse and other shady stuff on dark web. And that's also the main concern of the co-legislators. They want to make national competent authorities to actually gather on a consistent basis, so and in a timely manner, in order to mitigate these risks, and they need to cooperate. So it's really important. I think it's an EU principle that was disregarded for way too long now. And the rules about this unhosted wallets go like this. And the rules would also cover transactions from so-called unhosted wallets when they interact with hosted wallets managed by CASPs, something that I have already mentioned, but yeah, as a conclusion. Then in the case when a customer sends or receives more than 1K euros to or from their own unhosted wallet, the CASP will need to verify whether the unhosted wallet is effectively owned or controlled by this customer. Actually, what the first panelist mentioned as well. And I think it's also answered in the chat. And lastly, the rules do not apply to peer-to-peer transfers conducted without a provider, such as Bitcoin trading platforms or among providers acting on their own behalf. And I promised to do something, case studies, because I know this is a bit of legalese here. There are a lot of experienced participants here with these words and the mechanisms, but I want to make it a bit clearer. So let's go through this, okay, some more questions, case studies, I don't know how to call them exactly. Let's say that firstly, Jan sends one token worth of 200 euros to his sister by using his MetaMask wallet to her MetaMask wallet. Will the TFR apply here? You can insert some answers in the chat if you'd like to. Otherwise, I'm just going to answer them in the end. And will it apply if Jan, will the TFR apply if Jan used his Binance account to send to the MetaMask wallet of his sister that amount? Then, okay, people actually reply. So I see no, yes, no, okay. I'm going to answer it in the end. In particular, the agreement on unhosted wallet transfers. Okay. So yeah. Then the second scenario, Jan sends crypto assets worth of 20,000 euros to his sister by using his MetaMask wallet to her MetaMask wallet. Will the TFR apply here? This is actually really interesting, the second one, I think. Jan wants to send crypto assets worth of 2,000 euros to his son for rent in Amsterdam. He lives in Angola, so Jan lives in Angola, and has a cash wallet with a locally registered crypto form. Will the transfer go through, and how? And the last scenario, Jan wants to send crypto assets worth of 5,000 euros to his daughter who lives in Japan for new designer clothes every month. He lives in South Africa and he has a cash wallet with a locally registered crypto firm. His daughter also has a cash wallet from a firm registered in Tokyo. Will the transfer go through in light of this updates when they will come into force? Okay, unhosted wallets. I'm going through the chat right now. I think I still have a few minutes. I hope so. Unhosted is never under TFR regardless of the amount. Hosted and hosted. Unhosted is always under TFR regardless of amount. Yeah. Okay. So in the first case, this is the last thing, Hannah. In the first case, when somebody wants to send from peer to peer, there's no issue. You don't need to comply with additional requirements. It's just like sending cash. So even if it's going to be more expensive to send crypto assets through this unhosted wallets, it's still not supposed to ask additional information. And then in the second sub question, regarding the second sub question, will it apply if Jan used his Binance account? Well, since there is no threshold there, TFR will apply if he sent the assets from Binance to MetaMask. Second question, Jan sent crypto assets worth of 20K to his sister from MetaMask to MetaMask. It kind of depends here, but we need to identify the third party beneficiary of this transaction, in my opinion, even if they say that might not. So in my research, I don't think that this is really accurately expressed. So who will stop you to send 20K worth of assets, especially because of their highly volatile nature? So technically you would go through, but yeah, it remains to be seen. And in the third case, Jan wants to send crypto assets worth of 2,000 to his son for rent in Amsterdam. When he sends from Angola to so basically, because in the first scenario, because Angola is outside Europe, the other the recipient, his son, needs to have a cash wallet registered in the EU. Only this way it can go through, and of course, it's going to be subject to further information to the provision of further information because it's above the threshold. And then Jan wants to send crypto assets worth of 5,000. In this case, it's pretty interesting from two counts, because it says every month. It's probably, in the view of some KYC analysts, it would be a bit too high to send on a consistent basis. But if that's declared to be like the pattern, that will be fine. But because both live outside, both CASPs are registered outside the EU, one in South Africa and one in Tokyo, it's not subject to these regulations, so it's out of scope for us. But technically, if they are EU citizens and they conduct other transactions, somebody, especially if it piles up to like hundreds of thousands, somebody will raise question, hey, how are you doing this, etc., blah, blah. And the bank can pose certain harsh requirements then when they want to withdraw the money.
I need to cut you off, Sadri. Sorry.
That's all.
We have
that's really too so fast for me.
Thank you very much for sharing your presentation. I think that arised a lot of questions around unhosted wallets. We will not have time to go through them right after your presentation because we went a bit out of time. But as I said, keep an eye on our social media. We are really on top of that topic of unhosted wallets. Harm will also mention that on the presentation, and I think we will probably have time to go through the questions there. Thank you, Sadri, for joining. Harm, you're up.
Thank you.
All right, thank you, guys. I'm going to do a very practical talk. Let me share my screen here. Let me see. Right, I'll dive right in. I think you see my screen here now. All right, I euphemistically called this presentation Effortless Compliance. It is anything but. Let me put on the timer here before otherwise I forget. I'm that kind of guy. Okay, effortless compliance. It is anything but. If you want to comply with all the regulation coming out, you immediately run into a couple of problems. And most of these problems stem from the fact that you now need to talk to other VASPs. This complicates matters enormously, of course. If you just do KYC on your client, that's all neatly contained within your organization, but now you need to exchange data with others, so you immediately run into issues. One of these issues is the sunrise problem. Your counterparty is not compliant or not compliant yet, or has a different solution in place. I saw somebody in the chat mentioning trust. Others could be using TRP or Verify VASP or any other of these things. There is also the issue of VASP discovery. You get an address, and now you need to determine who owns this particular address. And I think the previous three talkers said this well. Cross-jurisdiction issues. So what to send when? Different jurisdictions interpret the recommendation differently. And there is also the privacy and data protection you need to be very mindful of, especially in the EU, luckily. All right, talk about sunrise. You have a travel rule solution in place, can be anything, but your counterparty does not. Now what are you going to do? If you look closely at the travel rule, you will see that you just need to gather this packet of data and send it to the counterparty. And you can just email them. You gather the data from your clients, all the required info, and email your counterparty. And for the travel rule, you are then done. How does that work the other way around, though? The counterparty, Binance, for example, they are always a happy example for compliance. Binance sends a carrier pigeon with the travel rule data, and now you need to do something with that. As you've seen, you need to store this data for 5 years, and we need to be mindful here why you are storing this data. When a financial investigator comes around, you need to provide all this data to this guy. In order to make your life and his life easier, it is important that you consolidate this data into one place. You can just export it from your favorite tool and then hand it over to this data. It will reduce the amount of things you're missing, and it just makes lives easier and thus cheaper for you as a COSP. Or even simpler still, Binance wants to send you a transfer, and you say, oh, you can do this, but only if you fill out this form of ours. You host a form, they will fill out all the beneficiary and originator information, and you automatically consolidate that into your single point of truth. So the Sunrise issue is actually quite hairy, but there are solutions into place in order to make this a little bit easier for you. Not on this slide, but as I mentioned, some are using Trust, some are using TRP, some are using Verify VASP, some are using Signa. There is a whole slew of solutions out there, and none of them are actually compatible. And we as 21 Analytics strive to give you a one-stop shop for these things. It is important when you engage in conversations with other parties that you make sure that these other people are multi-protocol and not just selling you one particular solution, because then you will not be able to talk to all your counterparties. All right, the VASP discovery problem. This is a tricky one. So you are giving a Bitcoin address from your client, gives you a Bitcoin address and says, hey, I want to send money here. I want to send coins here. To what VASP does it belong to? Or does it even belong to any VASP? Some of our clients just ask the user, right? Yeah, they fill out a Bitcoin address and then they ask the user, okay, fine, to whom are you going to send this? And they select unhosted wallet or they select Binance. But what if the user makes a mistake? Or even worse, lies? Also for these kind of things, there are solutions, of course. One of these solutions is a travel address. A travel address is something a COSP gives out to the user, say, hey, you want to make a deposit to us? Okay, send the money here. And they will give you not a Bitcoin address, but they will give you a travel address. Think of a travel address as an IBAN. An IBAN also has encoded in it the bank you're going to send money to, and travel address is the same kind of thing. So you no longer have a Bitcoin address or any other address really, but now you have a travel address. And with this travel address, the originator of the funds, the originating COSP, can resolve this travel address and figure out what to send where. For unhosted wallets, I think it was Willem-Jan who touched on this. For unhosted wallets, there is a variety of methods to verify ownership thereof. We've seen screenshots, we've seen the microtransactions or Satoshi tests, and cryptographically signing a message. None of them are ideal. Actually, we thought they were all pretty bad. So we sat down with one of the hardware manufacturers here in Switzerland, and we came up with address ownership proof protocol. In a very tiny nutshell, this just automates the flow of cryptographically signing and exchanging an address. So MetaMask, for example, supports this. As a COSP, you can show a QR code or a link. People click it. MetaMask pops up. Says, hey, you're about to verify an address to this COSP. Are you okay? Yes, done. You have cryptographically, you are certain to have this information. Do not rely on on-chain analytics. Barbara is going to disagree with me on this a little bit. On-chain analytics are a heuristic. They help, and I really do believe you should be using them, if only to guide the user. But relying just on on-chain heuristics is folly, in my opinion. Kraken, for example, will give you a new deposit address every time you want to deposit money. I think that's hygienic to do so, but this new green address, if you give that to your to the originating VASP, only analytics just can't deal with that. Onwards, we're going quickly. Cross jurisdiction, and this is actually very interesting, I think. The FATF recommendation 16 is just that, a recommendation. Some jurisdictions interpret it differently, and what are you going to send when? I was actually in Hannes' presentation. I learned that the EU actually requires a little bit more than what the FATF requires. Canada does the same. They additionally want the beneficiary address. Singapore wants a national identification number. Estonia wants a whole slew of other stuff. So once you've figured out, once you've solved the VASP discovery problem I mentioned earlier, then you now know in which jurisdiction this particular VASP is, and then you can ask your user the relevant fields. This is often overlooked, I think, and it's important to tackle this if you want to stay compliant and make sure that you can transact with all your usual counterparties. All right, privacy and data protection. Well, actually, the three previous speakers mentioned this elaborately. You are going to deal with personal identifiable information of the highest sensitivity. This is transaction data with amounts, with counterparties, with dates. How are you going to protect that data? Because this is vitally important. It is our conviction that as a CASP, you already do this. You are running KYC on all your customers. You have data protection officers. You have all this stuff in place, and it is our conviction that you, as a CASP, know how to do this best. That's why we think it's important to run your software on premise, because then you own the data. And you can deal with it in the way you see fit. I ran through this presentation. I'm going to keep this short since we're a bit out of time. Effortless compliance. I really hope we get there. Everybody in the industry is working hard to make this happen. We've seen, for example, mergers between different protocols. OpenVASP merged with TRP to make it simpler. And as 21 Analytics, we are actively engaging in the community to make sure that you, as a CASP, can actually be effortlessly compliant. I'll keep it at that. Thank you for your attention, and I'll give it back to Hannah.
Perfect. Thank you, Harm. Thank you so much. I guess since we're a bit out of time, I will just ask one question from the chat. I think you tackled that on the presentation, but maybe you can explain a little bit further. It's from Pascal. How does the proof of ownership protocol verify the controlling party's identity? Does it undertake proof of liveliness?
Sorry?
Does it undertake
no. So what this does, it will give your wallet, your unhosted wallet, a message to sign. Your wallet will generate a new address, so a new public-private key pair, and it will then sign these, or it will send the address and the signed message back to the VASP. So this is an interactive protocol. So in that sense, liveliness, right? You get this message, and then at some point you get the signed response. For a risk-based approach, you can of course see how fast you get this response. Are they spoofing it or not? But risk-based approach, I think, is important here. But the principle is, it's just clicking a button. Yes, it wouldn't take more than a couple of seconds. I hope that answers it.
Perfect, thank you. I will ask that people that have their raised hands, please drop your questions on the chat, and we'll get to the questions after the presentation and as form of new content, blog posts, following events, because I guess 1 hour and 15 minutes is definitely not enough. Yeah, Barbara, you're up.
I am, yes. I'll try to be super quick and shorten what I'm going to say to just a minimum. Let me know if you can see my screen.
Yes, we can.
Okay.
Perfect.
Right. So a lot has been said already about the EU travel rule and about the requirements. I just thought it would be good to put it in context and see where we are in terms of EU travel rule as opposed to other countries. So rather than going through that, I know the slides will be shared. I'll share with you, we'll share with you rather the comparison on between different countries. And at the end of the slides, you can see the actual sources. So I think it's just really good to kind of put it in context and know where we are on so-called of what I'd like to say flexibility line. I think the UK so far has proven to be ready for the most flexible approach. Nevertheless, if you compare what we are doing in the EU, as opposed to say Switzerland or the likes of Singapore, we are kind of in the middle, just because of the fact that, as we've spoken today, the verification of the information of the beneficiary and originator for unhosted wallet will not be explicitly required. There are requirements based on risk-based, so on a risk-based approach. And just going to that fairly quickly, focusing on the EU there on the right-hand side, what that means is kind of a twofold element. First, as we've explained already today, there will be a hard requirement for transfers over €1,000 to from unhosted wallets controlled by a CASP client. In those cases, the proof of ownership of the unhosted wallet is required. However, for other transfers to and from unhosted wallets between CASP and an unhosted wallet, what the EU is introducing is on a risk-based approach basis. What that means is that the transfers will require the application of mitigating measures that should be commensurate with risks identified. So something that has been present in other areas of AML, something that the UK has been particularly, let's say, focused on in different elements, but it would be really interesting to see how that works out in practice. And what I thought would be useful to do today is to kind of give you, let's say, some of my ideas on how that could be applied in practice, obviously with the use of blockchain analytics, and I'll comment on what has been said with the use of blockchain analytics for the identification of VASP wallets. So leaving aside blockchain analytics for a moment, what is a risk-based approach? It is being flexible in what you do. So identifying your risks and then different mitigating measures for those identified risks. So what risks we're talking about here? What kind of categories when we think of the travel rule? Well, first of all, there's always the client profile, the client risk rating, KYC. We cannot escape that, and it kind of is one of the main risk factors there. There will be different clients, different risks pertaining to different clients. Then we have different business relationships, different products, where there's a difference between exchange with heavy volumes or custody. Then there's the size of transactions, which has some explicit requirements, as we've seen today, and something which is very unique to the blockchain world, and that is the possibility of flagging risks on unhosted wallets, even not knowing the ownership, even not knowing who's behind that wallet. And to comment to what has been said before, I do agree, and I think I've been always kind of transparent on that. In blockchain analytics, when we rate whether a wallet is hosted or unhosted, so in other words, whether it's controlled by a CASP or not, we rely a lot on algorithms. So there's certain, let's say, certain data, black and white data, but there's also a level of prediction. And while that prediction is very high, I don't think any blockchain analytic could say that it's absolute 100%. However, what we do have, and again, sometimes not 100%, but to a high probability, is the possibility of risk rating, of flagging unhosted wallets risks that we identified. So say if your unhosted wallet has received 2 years ago small amount of funds from illicit source, that can be traced and marked in the blockchain analytics tools. And how that translates into your risk mitigating measures for travel rule, the way I would envisage that, and I'm putting here on the slide, it's an example, obviously, it's a proposal, it's just my thoughts on it, it's not nowhere in the regulation. I would think that, first of all, just in the wider AML, you can think of dividing your clients and your transactions into risk groups, say group 1, group 2, group 3. For group 1, which will be of the lowest risk, you can apply enhanced monitoring. So say monitor the addresses of unhosted wallets after the transaction takes place. There's a possibility with that with blockchain analytics too. For the group 2, which is kind of yellow, so the group with increased risk, an example of additional mitigating measure to apply would be to verify the ID and or to provide to do enhanced investigation of destination address, and then depending on the result, accept the transaction or reject the transaction. And then you can define group 3, where you'll always reject a transaction. And just very briefly showing, again, an example of how this can be done with the use of blockchain analytics is, I like to think of that as kind of like Lego blocks. You can basically pick the elements, pick the flags that you would want to have in each of your groups, in each of your groups that you would apply mitigating measures for. For example, anything to do with sanctions, links to crimes will always go to group 3, so reject the transfer. But there are elements that could warrant further investigations. For example, anonymizing services. If the blockchain analytics identifies a wallet having some transfers from anonymizing services, I think even in the draft of, at least the Parliament draft of the transfer of funds regulation, there was this level of flexibility to say there could be additional information requested to understand the rationale for the use of anonymizing services. So that type of flag would sit in your group 2, where you do additional checks and then decide whether or not to reject a transaction. So that's it really. I would be happy to go into more detail, but I know we're running out of time. Again, the slides will be shared. I'm always happy online to have a chat, to discuss, to bounce off and share ideas. I think that's the beauty of the online world we live in. And yeah, happy to engage in conversations.
Thank you, Barbara. Thank you also for being quite quick, and but I think it was very, very insightful. Great ideas on how to approach, and yes, I think we will leave it at that. As I said before, we will be posting content regarding the questions that we have. I see this was definitely not enough to cover everything on this regulation. Please do subscribe to our updates. I have shared it on the chat. And well, thank you everyone for participating and joining us. We will definitely have follow-up events on the topic. And yeah,
see you next time.
To hear about you. Yes, see you next time.
All right, thank you guys. That was really good. I really enjoyed every single last presentation. Nice.
Thank you too.
Cheerio.
Bye-bye.
Thank you.
Bye-bye.